For those who dare to contend with gender ideology, particularly in the courts, the process is often long and protracted. And in this Season 5 bonus episode of Generation Indoctrination, we are revisiting the ongoing case we've covered in the bonus episodes of Seasons 3 and 4. Ted Hudacko is a father who has been fighting in the courts for years after his then minor son underwent transgender medicalization in a gender center in San Francisco, California, in violation of a family court order. There have been so many twists and turns and hurdles in this arduous journey, and we've documented them in granular detail, featuring some of the voices who have helped this determined father at various points along the way. At the conclusion of the bonus episode of Season 4, we noted that Federal District Court Judge Susan Ilsen dismissed his case. He's now appealing to the Ninth Circuit Court of Appeals. Hudacko is determined to carry his case, which has many legal layers and allegations, to the very end in the interest of justice, not only for his son, but for other families who are enduring this nightmare. As the cultural tide continues to turn against transgenderism, and as federal agencies take action against hospitals and medical centers by withholding Medicare and Medicaid dollars if they keep carrying out the kinds of experimental procedures that were done on Hudacko's son, individual cases like his typically receive scant, if any, news coverage. And so today, we're picking up where we left off with an important update. So welcome back to Generation Indoctrination, Ted. Let's recap your story a bit to get started here. Several years ago, a doctor at the University of California, San Francisco, Benioff Children's, gender center, surgically implanted a hormone-blocking device in your minor son's arm. He was 17 at the time, and that went directly against the order of a family court, which explicitly prohibited any gender identity-related surgery. Now, you initially had a family court complaint and a federal suit, but you had to drop the family court complaint and then only pursue the federal case. And as we reported last time, that federal case, Judge Ilsen dismissed it. But you're soldiering on. You've appealed to the Ninth Circuit. What's happening and what's the big date coming up?
Yes, October 8th, 2025. That's oral argument in the Ninth Circuit Court of Appeal in San Francisco, beginning 9:30 a.m. Pacific. The judges literally are going to decide if it's legal for government doctors to medically experiment on children without proper consent. The court streams these sessions on Zoom. Please put a link in the description. Listeners also could go to www.ca9.us.gov/media/live-oral-arguments.
So what then happens if the court decides that medical experimentation on minors, again, your son was 17 when it happened, is legal? Usually, when these gender issues get before a court, they are narrower and they're much more technical. How did you get that particular question before the appellate court?
Well, it was straightforward. I put involuntary human medical experimentation in the complaint, in the Second Amendment complaint. Remember, Federal Judge Susan Ilsen dismissed my complaint. I haven't had a trial. I haven't even gotten discovery yet. So when reviewing a motion to dismiss, the court is required to assume all of my alleged facts are true and dismiss the complaint only if the complaint fails as a matter of law. She instead dismissed my case, finding that these doctors that transed my kid are protected by something called qualified immunity. Qualified immunity is a rule that says a government actor, which the UCSF doctors definitely are immune from lawsuit unless we can say that no reasonable government official would have believed this is legal. So I've hired a new law firm just to handle oral argument. The chief partner is Myron Moskowitz. He's an experienced Supreme Court and appellate lawyer. Myron believes we should prevail on our argument that no reasonable government official believed it was okay to do this implant.
I understand there are some, shall we say, rather complicated family dynamics in play here, as your ex-wife, your son's mother, consented to the puberty blocker in his arm. So can't she and the other defendants argue that they were just providing a sanctioned, approved medical therapy for your son?
Basically, my argument is twofold. First, the surgery was explicitly prohibited in a court order, and the UCSF doctors knew that. In fact, UCSF is mentioned directly in the court order. We're arguing that my right to prohibit surgery arises under the U.S. Constitution. There's a long line of U.S. Supreme Court cases saying the parent has the fundamental right to direct the medical care of his child. Secondly, not even the mother of the child can consent to the child's sterilization. That's under a California Supreme Court case, Valerie N.
Well, in the course of this case, Ted, you have also requested something called judicial notice of some historical events. Could you explain why that matters and why did you request that? What happened there?
Judicial notice is a legal procedure where the judge in the case is required to acknowledge a fact that's not reasonably subject to dispute. A case can actually turn on whether a judge will take judicial notice or not. We requested judicial notice of several historical examples of involuntary human medical experimentation, including the Nazi medical sterilization experiments from World War II, which led to the Nuremberg Code. I also requested judicial notice of the practice of lobotomy. Some people, including Harmeet Dillon, are calling transgender the new lobotomy. We also requested judicial notice of the Tuskegee syphilis experiments, of MK-Ultra, the Leo Stanley experiments. Our government has admitted these experiments certainly took place. Unfortunately, there are many examples of state-funded experimentation. Transgender is just another in a long series. What happened was Judge Olson denied judicial notice. That's one of the issues we're appealing.
Well, let's drill down a little bit more, given that sterilization and just the unethical nature of the experimentation that's going on here. Could you explain some of the risks of the drugs that were given to your son, specifically the Supperlin LA hormone blocking implant? What does that cause and why does that matter?
Well, remember, the factual issues around so-called gender-affirming care have never gone to trial. Never. We need to hear from expert witnesses about what puberty blockers and cross-sex hormones actually do to people over the long term. Certainly, sterility is a huge issue, but so is brain development. When doctors block puberty, they block brain development. That human brain continues to develop well into our 20s. So the doctors are creating a population of adults who not only still look like children, but who also think and act like children. My rights are at issue, but it's also the children's rights. Children have the right to go through puberty, and the gender ideologues have taken that away in order to continue their experiment. That's what we're fighting for.
And so in your appeal, you're also, I understand, alleging judicial bias. Can you speak to any extrajudicial source of bias that would justify Judge Ilston, or are you just simply disagreeing with her ruling?
Judge Ilston's conduct went beyond mere adverse rulings. She abstained from ruling on fully briefed motions to dismiss without any legal basis. She also gave legal advice to the defendants by suggesting that they assert qualified immunity, which they had not done so at that point. And Judge Ilston denied the judicial notice of adjudicated facts such as the Nazi medical atrocities and historical unethical experimentation. So these actions reflected procedural irregularities and favoritism toward the defendants, both violating standards set forth in United States versus Baca and In re Manoa Finance Company. The Ninth Circuit permits disqualification for bias raised on appeal when the record shows actual impropriety.
Well, and there's even another part of your case that centers on what we call state actor theory. Where in your complaint do you allege that, specific facts, not conclusions, that show Dan Harkins, and we've talked about him in previous episodes, and he was the minors' counsel who you are alleging facilitated your son's chemical sterilization, and that he acted in concert with state officials, officers of the court, to deprive you as a father of your constitutional rights?
So under the joint action test, nominally private actors like Harkins and Bigger, the other private attorney, are de facto state actors when they coordinate with government officials to execute a court order and conceal medical procedures. My complaint alleges a 20-minute phone call in which the defendants agreed to perform gender identity surgery despite the court order prohibiting it. And this coordination, it satisfies the standard that's in the case Franklin v. Fox, as well as the other case, Clegg versus Cult Awareness Network.
Ted, when we first spoke, your attorney spoke about the practice of fraudulent concealment. the legal duty the doctors at the UCSF Gender Center owed to you. They obtained consent from the custodial parent, your ex-wife, but you were not asked. You were never asked for your consent. This happened without your knowledge. So what's this fraudulent concealment all about?
So the family court order explicitly prohibited, quote, any gender identity related surgery, end quote, without my written consent. The UCSF doctors were named in that court order, and thus they had a duty to disclose the nature, the risks, the experimental status of the Supprelin implant, as well as their participation in the NIH puberty blocker grant study. Their failure to do so on any of these constitutes fraudulent concealment under California law, and it violates the informed consent doctrine established in cases such as Moore versus Regents of University of California, as well as In re Cincinnati radiation litigation.
So with respect to the conduct of UCSF, what about what they did rises to the level of outrageous under California state law?
Well, the conduct includes secretly enrolling children in experimental procedures, misrepresenting the safety of puberty blockers, and intentionally causing sterility and neurological harms. So again, these actions mirror the unethical experimentation that I mentioned from the case Cincinnati radiation, as well as the United States versus Stanley. Again, we can say if sterilizing kids isn't outrageous, what is? Other cases to reference might be Davidson versus City of Westminster, as well as that Moore versus Regents case.
Well, and there's another legal layer here as I'm reading through your legal documents. When Judge Ilston dismissed your case, there was this question of qualified immunity. Do you know of any case law that clearly establishes a constitutional right for a non-custodial parent to veto puberty blockers or cross-sex hormones, that legal custody rests with the other parent? Any case law to that effect?
The right to direct a child's medical care is well established as a liberty interest under the 14th Amendment. That's affirmed in Parham versus JR, Cruzan versus Director, and Skinner v. Oklahoma. The family court provided clear contours of this right in that court order. Additionally, In re Cincinnati radiation litigation held that officials who engage in non-consensual experimentation cannot claim qualified immunity when their conduct violates clearly established rights.
Well, and you also have conspiracy allegations. Like I said, there's many layers to your case here. You say there has been a conspiracy involving UCSF, the others, and yet failed to argue that in your appeal. Have you abandoned that theory? And as we've discussed previously, there's medical progress notes that you have, which I've reviewed, and they do show that doctors and others coordinated behind your back, seemingly conspiratorially, and all of that. Is that still part of your argument?
No, the conspiracy claim is central to the appeal. The complaint alleges coordinated action among the defendants to violate a court order and conceal medical procedures. At the pleading stage, detailed evidence is not required. Other cases, such as Park versus Thompson, Jones versus Johnson, affirm that conspiracy claims are subject to relaxed substandards when they're known only to the defendants.
So to wrap this up, Ted, I have to ask you a personal question now. What has changed in you from the last time we spoke, and even from beginning to end, really? I mean, you've been at this for years, and I think many people, after you've had to spend all the money on lawyers and other fees, all the logistical hoops and legal hurdles you've had to jump over and through, what's it been like for you to keep fighting like this year after year? How has this changed you?
I mean, someone once told me, and I think I've read, that the human body regenerates entirely over the course of 7 years. You have some cellular regeneration. Assuming that's true, and assuming it's a linear function of change, on a day-to-day basis, maybe 0.04% of your body changes. The new cells have replaced the old ones, which means that your overall rate of change is maybe only about 1% per month. And it takes 7 years to get to 100% turnover. So I'm 6+ years through this process. Time is just necessary.
Thank you for listening to the Season 5 bonus episode of Generation Indoctrination. And again, to watch Ted Hudacko's hearing before the Ninth Circuit Court of Appeals on October 8th, please visit www.ca9.uscourts.gov/media/live-oral-arguments.